Good afternoon. My name is Simone Chong, and I am here with my colleague, Diana Gonzalez, and we are with the Los Angeles County Department of Consumer and Business Affairs. Welcome to today's webinar, where you will learn about the options and requirements available to the party being sued, called the defendant. In the first part of the webinar, we will present a short video. At the conclusion of the video, we will be answering your questions during a question and answer session. Please take note that your microphone is currently on mute. You may ask questions at any time during or after the video by submitting them through the chat box located on the lower right of the WebEx interface page. It's a good idea to leave the chat box open even if you don't ask questions, because you will be able to view valuable information entered in the chat during the course of this webinar. This webinar is being recorded and will be available on our website along with other small claims resources. Just go to dcba.lacounty.gov and click on the Small Claims tab. At the conclusion of today's presentation, we would appreciate you completing a 4-question survey to let us know how we are doing and give us suggestions for additional small claims webinars. All feedback is welcome. Please start the PowerPoint now. Thank you. Hello again. Thank you for coming to this webinar where we will discuss the options and requirements available to the party who is being sued in the small claims case. The topics that we're going to be covering now are when you discover you're being sued, how you should contact the party who sued you, register for LASC online dispute resolution, known as ODR, requesting a dismissal, challenging the venue, requesting a postponement, if the defendant wants to sue the plaintiff, and also how the defendant can appear at the small claims hearing. Next slide, please. Typically, the party being sued, called the defendant, first discovers they are being sued when a server comes knocking on the door and announces, "These are court papers." The court papers are called the plaintiff's claim, and they were filed with the court by the party that started the lawsuit, called the plaintiff. The court papers must be handed to the defendant or to a person eligible to accept court papers on behalf of the defendant. The court hearing date is listed on the first page of the plaintiff's claim form. This is the date the defendant is expected to attend the hearing. Next slide, please. The defendant may respond in different ways. Before the hearing date, the defendant can register for LASC online dispute resolution and try to resolve the matter. If the parties are successful in reaching an agreement, there is a possibility the case may be dismissed. However, should the defendant believe they owe the plaintiff the full amount, the defendant can contact the plaintiff and make arrangements to pay and ask for the lawsuit to be dismissed. If the defendant feels they are owed money, they may file their own lawsuit. Next slide, please. When the defendant does not choose to pay the plaintiff the full amount of the demand, the defendant must register for LASC Online Dispute Resolution, referred to as ODR for short, within 5 calendar days of receiving the ODR notice. The notice should have been included with the plaintiff's claim when the court papers were served. To register for ODR, go to the website displayed on the slide. ODR helps parties reach agreements to settle their case online by computer without phone calls or meetings. If all parties agree on a settlement, they will not have to attend the court hearing. Review the form for specific details. Next slide, please. If an individual defendant wants to be dismissed or have the entire case dismissed, the defendant makes the request by submitting the form, Request for Court Order and Answer, and the number of that form is SC-105. The form is filed with the court and mailed to all the other parties in the case. Some reasons to request a dismissal are: the defendant believes that the plaintiff mistakenly sued the wrong party. The same plaintiff has previously sued the defendant for the same issue in the past. The defendant believes there was improper service of court papers, such as serving the court papers outside of California when the cause of action was not involving a vehicle accident or California real estate. Next slide, please. If the defendant believes they are being sued in the wrong county or the wrong court location within Los Angeles, the defendant can submit a venue challenge letter. A sample letter is on our website. Be sure to send the original letter to the court and a copy to all the other parties named on the case at least 15 days prior to the court date. When the defendant challenges the venue, the defendant does not have to attend the court hearing. On the day of the hearing, the judge will make a determination, and if the defendant is not present and loses the venue challenge, a new court date should be set for the parties to appear. If the court enters a judgment when you are not present, you have the right to file a motion to vacate, which is Form SC-135. On the form, be sure to include the Code of Civil Procedure 116.370, so you will be entitled to a new court hearing. Next slide, please. If the defendant is unable to attend the hearing on the court date listed on the plaintiff's claim, then the defendant can file a request for postponement and follow the filing instructions on the form. The instructions are on page 2 of the form. The request for postponement must be submitted at least 10 days prior to the hearing. Some reasons to request a postponement are: the defendant will not be available on the date of the hearing. Or another reason is the defendant needs more time to gather evidence and prepare for their case. Next slide, please. If the defendant wants to sue the plaintiff for money owed in another matter, the defendant can file a defendant's claim. That's form number SC-120. The defendant could also file their own lawsuit by filing a plaintiff's claim. The defendant might choose this option if they want to add additional defendants to their claim. What that means is the defendant's claim is a mirror image of the original claim. So if the defendant wanted to add more people to the claim, they'd have to initiate their own plaintiff's claim. However, if the amount the defendant wants to countersue is more than the small claims maximum, the defendant can file their case in limited or unlimited civil court for amounts over $10,000 and request the judge to have the small claims case transferred to the higher court by filing the form called Application and Order for Transfer. Next slide, please. Finally, the defendant can decide to appear at the hearing and present their case to the judge to show why they do not owe money that the plaintiff is requesting. If the defendant wants to appear remotely, they must register before the court date with LA Court Connect. Currently, one must register no earlier than 14 days prior to the hearing. The registration link is located on the home page of the court website. Litigants can request to appear remotely, either by telephone or video. Of course, litigants can also choose to appear in person if they choose. If the defendant is going to present evidence to the court, they must follow the rules outlined in the form, Exchange and Submission of Evidence. We happen to have a video on our website that describes that process very clearly. The same rules also apply in terms of submitting evidence if the defendant files a defendant's claim. Next slide, please. This concludes our review of the options and requirements available to the party being sued in a small claims case. Thanks for watching.
Thank you, Simone. That was a lot of really good information. We just wanted to remind everybody they can always go to our website, dcba.lacounty.gov, and under their small claims folder, you can go ahead and click on sample forms or watch any videos and webinars available. Simone, I think you may be on mute. Simone, I think you may be on mute.
I was muted. I was talking and I was
I
muted.
know.
Okay, so
No
I
problem.
don't know what you didn't hear, but what I had intended to say is we're going to have a question and answer period now. And Diana is going to field the questions. She's going to ask me them. And after I answer, Diana is going to contribute also to the answers. And the questions do not have to be related to the topic of our PowerPoint. It can be anything small claims related. Okay. You're muted, Diana.
It's like I clicked on it and then it didn't go
I don't
through.
hear you, Diana.
Can you hear me now? Can you guys hear me? It says it's not muted.
Well, I don't hear the questions. So is Tenny
Can you
gonna
hear
speak?
me? Simone, can you hear?
Oh, now I can hear. Okay, I'm sorry. Okay.
Perfect.
Okay,
So I was
technology.
just telling.
People. Technology. Okay.
We apologize. But as I was telling everybody, they can always go to our website, always look at our sample forms. We also have a lot of videos we've put together, previous webinars that may answer a lot of your questions. Feel free to put any questions you have in the chat box so that we can get started. I do see a question from a gentleman here. He might have left the chat already because he said he may not make it through the whole thing, but he wanted to know, how do I submit an MC030 declaration form, and also if he can include it with his exchange of evidence?
Yes, you can include it with your exchange of evidence. If you want to submit a declaration, generally it goes along with another form. So it's a little bit hard to understand what how we do it as a standalone form is if you have a witness statement and the witness wants to say what happened, then they would fill out the MC 030 and they would sign it. And then that could be submitted to the court along with the evidence. So the judge can review that. So I really need to know a little bit more about how he wants to use it.
And I think also if the declaration, which is the MC 030, if you're going to use it as part of your evidence because the witness can't come in person, you most definitely can submit it with the rest of your evidence. You can include it in the packet to the other party as well as in the packet to the court. So it shouldn't be a problem for you to mail it with the rest of your evidence. And then we do have Gregory who said, thank you for the great presentation. I have no questions. Gregory, thank you so much for attending. We appreciate your time and we hope to be here in the future. Another question we had here was, should I need to serve the other party? I guess it's related to the MC 030. So it was just what we answered about the evidence. Maybe we can touch a little bit on evidence exchange and the CIV 278-279, Simone.
Oh, okay. So interestingly, I spoke with a litigant on the phone the other day, and they submitted some evidence along with their plaintiff's claim. And the court actually returned it to him and said, please don't submit your evidence along with the plaintiff's claim. Please follow the rules of those two forms, submitting your evidence and the mailing labels. So that was a wake-up call in that the court doesn't appreciate your evidence attached at the same time. So the evidence that you're going to present to the court needs to be in the other party's hands and in the court's hands at least 10 days prior to the court date. So this gives the court enough time to process it and put it into your small claims case folder. And the instructions are on the page. It tells you step by step. There are 10 instructions that you photocopy it, that you include the form along with the evidence. And it's very important to attach to the envelope the mailing labels that are included, because the mailing labels list the court date and also the case number and time of the hearing. So that makes it easier for the court to process. The actual instruction form is found on the website lacourt.org under locally approved small claims forms, in case you don't have one as the defendant or the plaintiff, it wasn't given to you by the court.
Thank you, Simone. Another question we have here is, he wants to know, he or she, I wish to sue a client that didn't pay a bill for $1,000. The person just keeps saying that he and his business don't have the money. His business is in Palm Desert, Riverside County. So does this mean I would have to file in Riverside County? I'm a businessman in LA County.
It all depends the nature of your transaction. So if you're a businessman here, let's say you sell windows. So this person came in from San Bernardino, Riverside County, came into your store, and then ended up not paying. You could sue here in LA County because that's where the purchase was made. So it all depends what has transpired. Now, if you look at the plaintiff's claim that the plaintiff fills out, if you look on page 3 of the form, it asks you, why are you suing in this courthouse? So the main reasons are going to be where the defendant lives, which in this case he would sue in Palm Desert or whatever, or where the contract was signed or the work was performed. So being you have these 3 different criteria to look at, it doesn't have to be where the defendant lives. It commonly is, but it doesn't need to be.
The event for this specific question was a catering event that happened. So you could also go with whatever the catering took place. So if it happened in LA County, you can try that. But it really depends. There's various options, as Simone said. So you can choose any of them that apply best to you. Of course, the other party can always challenge the venue, but at the end, the judge will make the final decision as to what is considered the proper venue for you, if that makes sense, okay? Another question we have here is, how do I sign up to appear virtually?
Okay, on the homepage of lacourt.org, when you look at the homepage and you scroll down a tiny bit, there is something that looks like a computer monitor, and it says start your jury service here. Right to the left of it, in the left-hand margin, in a gold yellow tab, it says LA Court Connect, a new way to appear remotely. When you click on that tab, you can select small claims. They also have an instructional video over there in case you are having any challenges about signing in. That's where you would go. What they have done as of the present is they are requesting that you do not sign in any earlier than 14 days before your court date. And the reason is a lot of people might have signed in 30 days before the court date. Maybe they resolve the issue and they're not going to go to court, but now the court has already scheduled a remote appearance. So the court is giving you time to see if you can work out your issues with the other party. So it's 14 days or sooner. But you have to make sure that you don't sign up at the last minute. If it's less than 2 hours before your hearing, the court is unable to process your request. So the latest that you should sign in is probably the day before the hearing, just to play safe.
Thank you, Simone. And I think with that, maybe we should touch a little bit on the ODR system and what that is. It's a new system we have with LA Court to help people mediate. Maybe we can discuss that.
Okay, I'll speak a little bit and then you'll chime in. What it is that very often if people make an attempt to reach out to the other party, then they can resolve the issue without having to go to court. So one of the requirements now is at least to make an attempt to see if a resolution can be reached prior to the hearing. So when the plaintiff gets the plaintiff's claim form back from the court, the plaintiff should already log in to ODR so that it's good to go and it's ready for when the defendant is served the papers and they want to see if they can have a resolution. So when the defendant is served, instructions about ODR is going to be part of their plaintiff's claim packet, and it's going to give them the website where to log in. Also on our website, DCBA, we have 9 instructional videos about ODR and also help with signing in and how to negotiate with the other party. So it's highly recommended that you do this. I can't say that the court would not hear your case if you didn't, but the judge is certainly going to be more favorably disposed if you attempted to resolve your case prior to coming to the hearing. How do you want to contribute, Diana?
Everything you said was perfectly fine. Before COVID, we had the option for a lawsuit where you would show up to the courtroom and you would have the option to mediate with an actual individual there live instead of going in front of the judge. And because of COVID, mediators were taken out of the picture, and now the LA ODR system has come into play to help facilitate that opportunity. so that you can still try to mediate before the day of trial. And if you both want to mediate and you're just having a hard time coming up with a solution, you can choose a button and ask for a mediator to assist you. And then your case can actually be closed out if you guys agree on something with the help of a mediator. So long as you both are interested in mediating, LAODR is a great tool and it may help you keep you out of court. Another question we have here, Simone, is I was never served papers. Do I need to prepare and appear in court? I learned about 2 lawsuits from third-party attorneys. I am currently with debt consolidation company who has been trying to negotiate my debt with the first plaintiff and currently on repayment plan with the second plaintiff.
Okay, so I'm a little bit confused because you said that you heard about it through attorneys. Generally, that means it's not a small claims case because it's,
No, Simone, he's saying that he learned about 2 lawsuits from third-party attorneys.
I
Yeah.
see. Okay. So,
Maybe he can clarify in the chat.
okay, because if a lot of debt collection is done in regular civil court. So for instance, if I'm being sued because I'm delinquent in my MasterCard or whatever, a MasterCard doesn't go to small claims court. So it's called a collections case. And what you get served to you is something that will say summons on the front of the paperwork. And it will also say respond with an answer within 30 days. Small claims cases, you don't need to respond prior to the court hearing. You need to register with LAODR, but you don't have to respond to the court officially. So generally, you show up if you're served the court papers. Another thing is, maybe you were served, but you don't know you were served, but they say you were served. So if you have your case number, you can check your case on lacourt.org, and you can see in your case history if it says that the service was submitted. So if it was submitted, then maybe there was some kind of a glitch, but it means if you're not there at the date of the hearing and the judge has received the proof of service, you could end up with an uncontested judgment against you. So you always want to check on the court website to make sure.
Yeah, I want to clarify. I do see here our consumer has said they've never received the summons. Unfortunately, whether you've received a summons or not doesn't always tell you what the court has. So if the other party submitted that they have served you, whether they lied or they served your neighbor or whatever the issue, that may be different from what you're thinking. You're thinking, I was never served. According to the court, you have been. Whether it was a lie or a missed service, the court has no way of knowing that until you let the court know somehow. I think step 1 is going to be to check your case. I'm going to, in the chat, put the direct website for you to do a case lookup. You can look up each of your cases and it'll tell you what type of case it is. If it is a small claims case, please feel free to reach out to us at our 800 number, and we can definitely assist you with what you would need to do. If it is not a small claims case, you can always still give us a call at the 800 number, and we can assist by providing you with either an attorney referral number, or we can try to assist you by providing you a self-help number, depending on what type of case it is. So definitely verify. You can give us a call and we'll guide you regardless of what it is, but we just don't know specifics on cases other than small claims. But remember, being served personally doesn't mean that according to the court, you have not been served in some other way, or that somebody has lied about you being served in some other way, if that makes any sense.
When you examine your case number, what the court is doing in the last about 5 years or so, if it's a small claims case, it has the letters SC in the case number. So it'll have something like 21 VESC 12345. So that's the dead giveaway when somebody calls us up and we say, what is your case number? And if they're giving us something like an LC instead of an SC, we go, oh, that's not a small claims case. And they might say, well, yes, it is because I'm only being sued for $5,000. And so that's within the small claims maximum. But that doesn't mean anything. You can have a regular civil collection case for under 10,000 filed in civil, unlimited, or limited court. So it does not have to have anything to do with the amount you're being sued for.
Thank you, Simone. That's exactly right. And then we're going to go on to another question here. If you want to contact the party that is suing you, what ways can you do that? How can you get in contact with them?
Well, one of the ways we talked about is if you're being sued is through this online mediation, LAODR, because both parties are supposed to register. The other is when you're being sued, it lists the plaintiff's information. The plaintiff is the person who started the lawsuit. The defendant is the one who's being sued. So their contact information is going to be in your paperwork. So you can reach out to them either by phone or by mail, and try that way if you have an interest. So we highly recommend our mediation service, but if you want to bypass that and meet with them directly and resolve it on your own, that's an option. You can do that also.
Thank you, Simone. Another question I have here is, as a defendant, as the person being sued, am I able to ask for a dismissal of the case? Can I submit the form CIV 110?
No, it can only be submitted by the plaintiff. It has to be the one who initiated the lawsuit. But if you have an agreement with the plaintiff and say, okay, I'll pay you what you're asking, but only if you dismiss the case. So there have been instances where the defendant meets with the plaintiff, hands them the money that's due, let's say $4,000, and say, okay, here's $4,000, but I want you to give me a signed request for dismissal, which has to be signed by the plaintiff, and then the defendant can turn it into the court. So this way, the defendant is assured the case is going to be dismissed. So it can be handed into the court by anyone, but it has to be signed by the person who started the lawsuit.
Thank you, Simone. Another question we have here is, can you go over the reasons when you can challenge the venue?
Now, a lot of things are in a gray area when it comes to challenging the venue. So let's say, for instance, I'm a photographer in San Francisco. A couple from Los Angeles is having a wedding in San Francisco. So they hired the photographer in San Francisco. The venue, which means where the wedding took place, was in San Francisco. But maybe the contract, because they went back and forth on the internet and they sent each other certain things, one could argue that it was signed in Los Angeles or even signed in New York or something, okay? Now, so the plaintiff wants to file in Los Angeles because that's where the contract was signed. But the defendant is saying, wait a minute, the wedding was in San Francisco. My photography business is in San Francisco. It's a real hardship for me to go to LA. Then it would be up for the judge to decide, given he has to weigh the needs of both parties, if in fact it should be filed in San Francisco. When in theory, it can be filed in both places. Both places are correct. But that has to do with the judge's discretion in thinking which would be the most fair to the parties. So it's not always just a cut and dry thing that's just obvious and do it one way. There is a lot of middle ground that you need the judge's decision for.
And I also want to state that recently, because of the LA Court Connect system where you can appear virtually,
Exactly.
sometimes challenging the venue isn't even worth it anymore because you can appear to court virtually by camera or by phone. You actually don't have to go down there. So a lot of times when people were trying to sue and trying to not sue in LA because they're not in LA, now they're feeling more comfortable suing from a different state and not having to fly out here. That issue is kind of resolved, and we hope it continues that way, because it is facilitating the lives of a lot of people to be able to appear virtually. It is causing a little more problems with the evidence exchange, but at the end of the day, it saves you a trip, it saves you a flight, so it may be worth looking into. Another thing that I thought we could go over here was the process of requesting a postponement, Simone, because it is a little bit complicated. Maybe some of our consumers would like to know the process there.
Okay, so if we start with the defendant who wants to request a postponement. When a defendant wants to do that, it is best to do it a minimum of 10 days prior to the court date. And if you look at the form, it actually says, are you requesting this any shorter than 10 days? And if so, why? So the form itself is sensitive to that time frame. So in terms of the defendant, if they do request it on that form, they're supposed to make a copy of that form and have someone other than themselves, a third party, mail that to the plaintiff, the copy, to let the plaintiff know they are requesting a postponement. So what the court wants to have then from the defendant is three things. They want to have the original request to postpone, SC 150. They want to have a proof of service by mail showing that somebody mailed a copy of this request to the plaintiffs and the other parties. And they also want a $10 fee. So that's now, let's say, for instance, it's 2 days before the hearing, and suddenly the person gets drastically sick and they're in the hospital. So now you are requesting it less than 10 days before the court date. Being that's the case, the clerk does not have the authority to give a new court date for the hearing. So you turn in the form to the court, and then the judge would see that at the time of the hearing, and his estimation, if he thinks it's a legitimate reason, you certainly didn't know that you were going to get sick 10 days in advance. And then when the judge reviews it, there's a good chance that the judge will then postpone the hearing. Now, in terms of the plaintiff asking for a postponement, generally that's done if the plaintiff hasn't been able to serve the court papers in time. So now it's 10 days before the hearing date, and you need at least 15 days before the hearing date to serve for personal service and 25 days for substituted service. So the plaintiff goes, well, I need extra time to serve the papers. When the plaintiff turns in that paperwork, they do not need to pay the $10 fee because the request is being made prior to service. Now, sometimes there is a little bit of confusion because on the form itself, it says you're supposed to notify the other parties if you want to postpone. So a lot of people call up and say, do I need to do that? I haven't even been able to serve them. Why should I notify them that I'm postponing it and I haven't served yet? So that is a bit of an unanswerable question. I have seen some courts waive that and figure, well, if you haven't served, you don't have to notify them ahead of time. And there are other courts that stick to the exact instructions on the form and say we need to have the proof of service by mail to the other party, even if you haven't served them. So you'd have to ask the court clerk at the location where your case is what they require. but there is no fee for that. The other reason a plaintiff might want to postpone it is they have an unexpected conflict, also somebody got sick, etc. So if the papers have already been served and the plaintiff wants to postpone it, they will have to pay the $10 fee.
Thank you, Simone. That was some great information. I do want to remind our consumers that we have about 15 minutes left. So if you have any questions so far, anything confusing, anything at all, please feel free to put it in the chat so we can help. Another question we do have here is, what are some reasons to submit a defendant's claim? Is that like a response?
Okay, it doesn't have to be a response. Let's say, for instance, I'm the landlord and I have a tenant who's suing me for the security deposit. So the security deposit was $2,000. I have returned $1,500 because that was the damages to the apartment. And okay, so I would have returned $500 of the $2,000 because $1,500 is the damage. Now, the tenant believes they left the place in pristine condition. It's perfect. So they're saying $500 doesn't cut it. I want to have all $2,000 back. So they're suing the landlord for the $1,500. The landlord is not going to file a defendant's claim because all of their expenses were covered. So they're simply going to defend to the judge why they kept some money out of the security deposit. But let's say the landlord had $3,000 worth of expenses to fix up the apartment. So they kept the $2,000. They might not want to be bothered for taking the tenant to court for $1,000. They were going to let it go. But being that the tenant wants their money back, they figure, well, I got to go to court anyway. So if I have to go to court anyway to justify why I'm keeping the full security deposit, I might as well file a defendant's claim for the additional amount of money that is owed. So the bottom line is, if the defendant doesn't feel they're owed any additional money, they wouldn't file a defendant's claim. But if they feel they are owed money separately from the issue at hand, in addition, then they should file a defendant's claim. Now, as we talked in the video, a defendant's claim is a mirror image. So if the defendant, maybe they were only sued by one of the tenants for the security deposit, but the landlord feels all the tenants owe them for damage to the apartment, then the landlord would have to file their own plaintiff's claim because they want to add additional plaintiffs on the form. So that's when you would deviate from the defendant's claim if you want to modify what you were served with. Help me out here, Diana.
Perfect. And yeah, I mean, a lot of people believe that for every lawsuit you have to respond. And a lot of people call us saying, oh, I need to respond. I need to submit a defendant's claim. And no, for small claims, you do not have to respond. You can either try to resolve the issue or show up to court and bring your evidence and tell the judge, you know, this is not me, or yes, it is me. I want to do payment plan, whatever you want. So there's no response. The lawsuit, the defendant's claim is because the other party owes you money. And another thing is, if, for example, you have been sued previously from this person for something else and they won, you can't go back and sue them again for that money back. You can only sue them for something else. If a decision was already made on that money, then that's it. You can appeal the case if you went in person. You can try to fight it. But other than that, you can't go and submit another lawsuit claiming the money that you lost in a previous lawsuit. So that's another question that we get a lot. Let's take a look at our questions here. So Let's talk a little bit about the experience of appearing in a hearing, Simone. What's the experience for the plaintiff, the defendant, the time? Let's talk a little bit about that. We have 10 minutes left.
Okay, great. So most hearings are between 10 and 20 minutes. When you are called up in front of the judge, it is the plaintiff who speaks first, because the judge wants to know, why are you here? What happened? You're not really permitted to stand there and read a statement. You can bring notes with you to refer to, like I do in this webinar, but you just can't sit here and read. The judge wants to hear your story in a very candid, open way in terms of just conversation. So generally, the plaintiff speaks for about 5 minutes, and then the judge will then turn to the defendant and say, okay, what is your response? It's very important not to interrupt. So if the other party is speaking and maybe they're saying inaccuracies and you are upset with some of their statements, you really just have to wait until it's your turn to talk and then tell the judge how you disagree with the earlier statements. So the defendant then would speak, let's say, for about 5 minutes. The judge is going to review evidence from both parties, and then the judge is going to ask some questions. So to get better clarification, ask the plaintiff and defendant, etc. And afterwards, generally what the judge will say is, the decision is going to be sent to the parties in the mail. Occasionally, the judge might announce the decision in the courtroom, but it's rare. If the judge wants people to come back again for additional information or has certain reasons that the hearing should be continued, that is also a possibility. But the typical case is, after 15 minutes, the judge says, you'll get the decision in the mail. When the decision arrives, if the defendant feels that they should not have lost, they have the right to appeal the hearing, appeal the judgment within 30 days from the date that the judgment was mailed. If the plaintiff does not prevail, they don't get their money. A plaintiff does not have the right to appeal. The only thing they could do is to ask the court for reconsideration, which is done on the form SC 105, saying, I'd like the judge to evaluate the information again. I also have new evidence to present, so that perhaps the judge might decide on a different judgment. So just understand that when the person fills out the plaintiff's claim, they say right above their signature, they understand that they have no right to appeal the determination of this hearing. Now, being that we talked about the defendants in our earlier presentation, when a defendant files a defendant's claim, then what happens is either party can appeal. Now, the plaintiff who initiated the hearing, who ordinarily had no right to appeal, they can appeal if they're found to owe money. So when that happens, it's a redo of the entire case, the plaintiff's claim and the defendant's claim. That's the only way that the plaintiff has the right to appeal, is if the defendant has filed a defendant's claim. I'm done.
Perfect. That was a lot of information, but it's really good information. It was very well rounded. And I guess one of the last questions we have here, as we only have 7 minutes left, is if I lose the case, in what ways can I pay? And what if I don't have any money?
Okay, we're about to have a new video that's probably going to come out in about a week or so about paying your judgment. So I'm trying to think. Okay, so I believe there's 3 ways that you can do it. One is you contact a person that you owe the money to, and you and mail them a check, or you pay them in some other fashion. Another way is to request to make installment payments, because what if the judgment is large, let's say $8,000, and there's no way you can come with that up with that in one lump sum. So there is the form SC 220, which is a request to make installment payments that the party would submit to the court along with a financial statement. And if it is reasonable, the judge would approve those installment payments. Another way of paying the judgment is to pay it to the court, because sometimes there is a very contentious relationship with the other party. You really have bad feelings, so you don't want to pay them directly. You don't want to see them again. So you can always, for a $20 fee, pay it directly to the court. So your check is made out to Los Angeles Superior Court. The court cashes your check and then mails a check to the party who's owed the money. So those are the three ways you can pay.
That's correct. And I just wanted to add a little insight. If you do want to do payments, for example, and what I would suggest is to make sure you do them through the court. Why? Because through the court, as long as you're maintaining the payments and not missing any, you are staying out of owing interest in the period that your payment plan is approved until the payment plan is removed. In case if you miss a payment, it could be removed. In that period of time, you're not paying interest. Whereas if you and the other party have your own verbal agreement, it's not directly through the court, so the interest can still be charged. The interest definitely depends on the amount of the judgment, but it is 10% of that judgment per year. So it really depends on the amount. It could be anywhere from a cent to 30 cents, depending on your judgment amount. But I do suggest if you want to do payment plan, go through the court in order to not pay interest in that period of time. And the other thing,
I just want to add one thing to that. That's
yeah,
exactly correct. Except when you make the payments, let's say $100 a month, it's made to the other party. It's not made to the court. The court
correct.
does not accept installment payments. They will approve your plan, so it's interest free, but you actually have to send the money to the other party.
Exactly. And we have another question here. What if the 30 days has lapsed and the defendant did not appeal or pay the plaintiff? What are the next steps for the plaintiff?
Well, now the judgment is collectible, because after 30 days, it's now a final judgment. Now, it all depends what the assets are of the person or the business who owes you the money. So if it is someone who has a regular full-time job, who gets a paycheck every couple of weeks or once a month, you can do a wage garnishment. Or if you know where they bank, you can do a bank levy. Now, a lot of these collection methods are listed on our website, but what's important to evaluate is who owes you the money. Do they have any money? So if you're suing someone who, let's say, because of our situation now, people might have been unemployed, if they don't have any money at this time, you're not going to get any. But fortunately, judgments last for 10 years and can be renewed for an additional time before they expire. So you might have a judgment that is due now, but if that person is under financial hardship, you can wait a year, or you can wait additional time until you collect. But check out on our website for the different collection methods.
Yeah, absolutely. And that brings me back to the end of the other question, which was, what if the defendant has no money? And that's pretty much what Simone is saying. You are limited in your collection ways. You can collect from bank, you can collect from wages, you can place a lien on the person's home as long as they own it by title. You can suspend a driver license if the lawsuit was regarding a car accident that happened on a California highway. But other than that, it is limited. you're not able to go and send the sheriff to their house to pick up their television or anything of that nature. So definitely look into it before your lawsuit, and as long as you have some patience, hopefully you're able to collect from that person at some point. And since we don't have any other final questions, that's pretty much it. Thank you so much, everybody, for coming. Great questions all around, and we hope to see you soon. We hope that this helped you all.
Thank you
Anything else?
so much. And don't forget that little survey so we know what other topics you'll be interested in the future. Okay, thank you very much.
Thank you,
Bye for now.
everybody. Have a great afternoon.